Hi everybody, it's Wayne Jones, the course coordinator for Australian Employment Law. This is week 4, and in this week we want to talk about setting some minimum standards for the employment relationship. We'll be taking our reading from Stewart's Guide, and I'd like you this week to read Chapter 7 of the Guide, which deals specifically with minimum standards, two issues, namely the National Employment Standards and the Modern Award. Quite interesting, the current system, in as much as the original award system was what set the safety net. So under the original award system, which was in place for very many years, the awards set the minimum standards. Wages, allowances, hours, leave, how to handle disputes, meal breaks, you name it, everything was thrown into these awards, which set the standards. And remember from previous reading that they didn't always relate to an enterprise. They were usually based more along the lines of the type of work which was being done. So you had clerical awards for people who were doing clerk work, awards for mechanics, awards for people who were doing grounds work. They operated with the force of legislation, so once an award had been approved by the Commission, they did have the force of legislation. They applied to multiple employers because, remember, they were dealing with either industry, sector or occupational coverage. So if you were covering mechanics, you covered them across, say, all service stations throughout the state. Everybody who worked in a mechanics business in wherever it was throughout the state. Although there were two types of awards. Those where the people were, the businesses were respondents, so they were named, and that often happened. You'd hear about people being roped into an award hearing. They'd be served with papers, perhaps because they were a big employer of employees of that particular type. And then you had common rule awards, where the award itself just referred to the broad class of occupational members. No real coherent pattern, and so thankfully that's now behind us. The new award system came in the 1990s, very much a move towards a safety net for workplace bargaining. So just to be clear about that, the award would sit below and I suppose provide a level of comfort for employees who were about to enter into workplace bargaining. They knew they had this safety net below. The agreements, or they knew agreements could be made without reference to the awards. And the first of the safety net, or the legislated safety net provisions, came in at that time, and that was the Australian Fair Pay and Conditions Standards. And they've now, of course, been replaced by the National Employment Standards, but big changes in the 1990s. Where are we now? Well, under Fair Work, awards are going to set a floor for enterprise bargaining. Modern awards were required to be simpler and much fewer in number, and legislation would now set that safety net. So remember, we had previously the Australian Fair Pay and Conditions Standards. Legislation would now create the safety net standards through the National Employment Standards. More about those in a minute. So the National Employment Standards, they appear in the Fair Work Act. So they're standards which are set by legislation. In other words, those standards will always be there until the Act is changed. Quite an important point to make. Those national employment standards are always going to be there and be applying to all types of employees for so long as the Fair Work Act remains. So 10 standards. In short order, I'll ask you to have a look at them for yourself, but in short order they provide for maximum hours, flexible work, parental leave, annual leave, personal leave, community service leave, and leave during public holidays. So there's a bit of a flavour of hours, work, leave there. Now they also provide for the reasonable period of notice for termination when a contract comes to an end, and also redundancy pay. So when the contract does come to an end, when the employment relationship's over and terminated for one reason or another, what's reasonable periods of notice, what's a reasonable amount to receive as redundancy pay. And they also provide that everybody who starts work should receive a Fair Work Information Statement, and there's a copy of it there on the slide which shows the heading for it. So everybody gets the Fair Work Information Statement, which sets out the 10 national employment standards. Remember from your reading too that you only get one each year. So if you do a series of contracts over a period of 12 months, you'll only receive one in each 12-month period. So who do these national employment standards apply to? Well, look, as I said before, these are standards that appear in the Fair Work Act. So like all legislation, national employment standards apply to everyone who's a part of the national employment system. So if you're a national system employee, you're going to be covered by the national employment standards. It doesn't matter if you are covered by an award, an agreement, or even no instrument whatsoever, the national employment standards are going to apply to you. The terms cannot be excluded or modified except by the Act itself, so those standards are going to remain constant. Now, I'll just step aside for a second there and remind you that when we were looking the other day at who employees were and about special types of employment, remember specifically that if you were a casual, the national employment standards were varied so that you didn't receive holiday pay, etc. So that's what I mean when I say that the national employment standards apply to everyone, but they cannot be varied except by the Act itself. And if you're not sure about that, have a look at Section 86, Section 95 and Section 123 in the Act, and they just confirm that yes, it can be varied with respect to casual employees. So they apply to all national system employees. Doesn't matter whether you're covered by awards, agreements or no instrument whatsoever. Can't be excluded, can't be modified except by the Act. You can improve on them, but you can't swap them for, say, a different entitlement. You're always going to be entitled to that minimum number of weeks holiday, and you can't buy that off, say, with an additional payment. They can, however, be regulated or supplemented. And when I say regulated, I mean there are provisions in the Fair Work Act, for example, that say that certain leave can be cashed out. Have a look at the commentary regarding calculating service. I don't think it's as complex as it looks at first glance. Just have a close look at Section 22 in the Fair Work Act. Essentially, calculating service, and remember we need to calculate service to work out various entitlements under the National Employment Scheme and under the NES. That's why we're calculating the period of service. Service equals the period of employment. So under the National Employment Standards, you're entitled to certain rights, benefits, whatever, if you've had a certain period of service. Service accounts to employment. You can have a series of contracts and jobs, and they are going to be rolled together. But interestingly, have a look at the commentary regarding resignation. In that case that's mentioned in your text, Tevil and Rismus, for example, the lady threw in her job at the TAB when her wages were docked an amount of $80. She eventually cooled down somewhat. She returned her keys and she definitely resigned. She rejoined after she was prevailed upon by another staff member to come back, because I think she probably enjoyed the work. But interestingly, when it came time later to calculate continuity and periods of service, even a short period of around a week was enough to break that continuity of service if you actually resign. When you're taking paid leave, that's still calculated as service, so service is not broken for that. Unauthorised absences are excluded for the purpose of calculating some entitlements. But basically, if you have a closer look at Section 22, you'll see there's two calculations that you're doing. If you're trying to work out whether someone's entitled to leave, then really they have to be at work. So even authorised periods of absence, with some exception, they're not thrown into the pot for the purpose of calculating leave. But when it comes time to work out how much notice you should get, for example, if you're being terminated or being made redundant, you look at the period of continuity of service, and so that's more generous than the former one. But leave, generally, you have to have been at work to be calculating, to be adding into that calculation. All right, let's have a quick talk about modern awards. The guiding principles for the new modern awards were meant to be these. They're meant to be simple. Remember I said to you at the outset that the initial awards carried or dealt with quite a few different topics, subjects, whatever was really on the negotiating table could end up in an award. Well, modern awards were required to be much different. For a start, they were required to be much more simple. They were required to be much smaller in number. They would be primarily along industry lines. So we're talking about a common rule type award. You didn't need to be a respondent to be roped into the award. So they were going to be the new rules about these modern awards. They're dealt with under the Fair Work Act, under Part 2.3 of the Fair Work Act. So have a look at that section in the Act. Interesting thing about these awards, I think this is interesting, is that they are reviewed on a 4-yearly basis. So I'm aware that in 2016, for example, the underlying modern award, which deals with a lot of the primary industry, fruit pickers, etc., around the Bundaberg region, somewhere that I used to work. I know that award is currently in the middle of its 4-year review. Section 134 of the Act says that the objective of these modern awards is to create a fair and relevant minimum safety net of terms and conditions. And then it lists a whole lot of determining factors that are to be taken into account. Now, in taking these things into account, they keep coming back to the objective, a fair and reasonable minimum safety net. So have a look at the sorts of things which are taken into account under Section 134. This is the other thing that I think is quite interesting about the modern award. It's unusual for them to be varied outside of the 4-yearly review. So I guess if you go back to the original reasoning behind the creation, they were looking at the creation of a much more simple document and fewer in number. So not unusual, I think, for government to then say, and look, we'll really only want to revisit them every 4 years. Now, Section 160 of the Act says that various bodies can come back. That includes employer organisations, employee organisations, etc. But they can really only come back for a second go outside the 4-year period to remove an ambiguity or an uncertainty or to correct an error. It has to be something that's necessary, not just desirable. The awards can be varied with an individual flexibility arrangement, and I think this harks back to probably previous conversations we've had about the underlying motivations for the Fair Work Act, and that is to create a much more flexible work environment. So I guess in line with that, Section 144 says every modern award has to allow these terms. If the parties themselves want to negotiate some flexibility in the award, they can do so. There has to be genuine agreement. The employee has to be better off overall. There needs to be some process for terminating these flexibility arrangements if they really don't work out the way the employee was expecting, and the employee must receive a copy of those in writing. Again, in line with simplification, modern awards have permitted content. So have a look at sections 136 and 137 in the Act, there's a fairly limited list of matters that a modern award can deal with. And Section 138 takes us back to that idea that the terms must relate back to the modern award objective, which was, of course, that safety net on fair terms and conditions. Section 139 deals with just the sorts of things that can be included in a modern award, and I'll ask you to have a look at those for yourself. There's some content that's not permitted. Look to sections 150 through to section 155 in the Fair Work Act. An example of a couple of the things that can't be in an award, a modern award, and they're not going to be any surprises, I don't think. You can't have something in there that contravenes the general protections that the Fair Work Act gives. You can't include a bargaining fee, limits on deductions from wages. You can't have something in there that's discriminatory. And sections 55 and 56 of the Act already confirmed for us, I think, that you can't exclude something that's in the National Employment Standards. There's good commentary in your text regarding the language of the Act around coverage and application. Section 48 of the Fair Work Act says that a national system employee is covered if the award is expressed to cover them. And as you've heard me say, they're usually covered because they're part of a class. Look, here's a couple of examples for you as to the way someone is said to be covered. And this is from the ambulance award. So coverage 4.1, this industry award covers employers throughout Australia in the ambulance and patient transport industry and their employees in the classifications that are listed in the schedule. So then you go to the schedule, and I've just got a very short extract of something which was in fact many pages long. There's the very first one. So the employer is in the ambulance and patient transport industry. The employee does these sorts of things. So here's the first one in the classification, B1.1, ambulance officer. Employee who holds the qualifications of Bachelor of Health, Science degree, paramedic, or a similar degree, has another equivalent accredited qualification. The principal duties include assessment, treatment, care, and transport of emergency and or non-emergency patients in a pre-hospital setting. And then on from there, you've got the student, paramedic, etc. There are lots of other examples of employees. So that's coverage, and also gives you an indication of the types of employee that are going to be included. The text refers to the issue of dual coverage, and that's where somebody does a couple of different types of job. Good example given in the text is the one where the person works a few hours in a small business, say like a very small bowls club, might work a few hours mowing the grass, and then the rest of the day they might be a bar worker and working behind the bar. So a good example of a dual coverage issue to be dealt with. Not really covered in the Act in any detail, so the Act doesn't really deal with it much. So you come back to I guess the custom and practice and the common law. Common law cases usually looked at what type of work constitutes the major and the substantial employment. The textbook points out that these days, in a modern award, there's a fairly standard clause now that says, well, we'll apply that classification that's most appropriate to the work performed by the employee and to the environment in which the employee normally performs the work. And I think harking back to that ambulance example before, you could, if I jump back to it, you might think about it this way. You might very well have a person who fits into that first classification there, but 2 days a week, say, works for the university with the permission of the ambulance service, training new trainees. Another good example, you see. So standard clause would say, well, we're going to classify you the way that's most appropriate to the work that's performed. There is a mention of there is a mention of application of the modern award. To contravene the modern award is a breach. It results in a civil penalty. Look at section 45. There may be coverage, but the award must apply, otherwise it doesn't have any effect. Sounds pretty self-evident, but you have potential coverage, but it must have actual application to the employee to have effect. And Section 47 gives us some clues as to what that means. An act could cover you, but it's only going to apply if, well, first of all, that you do have coverage. Secondly, the award is presently in operation, so it hasn't been superseded, withdrawn, what have you. And there's nothing else in the Act which precludes you being covered and being applied. And the two examples that are given, I think, are that there's an enterprise agreement in place, or that you're a high-income employee. So just get your head around this. We're talking about there's a perfectly good modern award in place. It could potentially cover you. Why might it not cover you? Well, the first of them is that you might be a high-income employee. The modern award under Section 47.2 doesn't cover high-income employees. I haven't had an opportunity to check the figure, but as at last year it was 133,000. That's at 2015. And that income has to be guaranteed in writing and accepted. So you're a high-income employee, you've probably got your income guaranteed in a contract. And the second one, which was probably even more important, was a modern award is not going to apply to you if there is an enterprise agreement that applies to you. Importantly, even if the modern award touches on topics, subjects, whatever, that aren't really covered in your enterprise agreement, that doesn't matter. An enterprise agreement effectively takes over. So it's not like there's a strata of all these different things that you can refer back to. This is the first indication, I guess, that if you've got different and competing instruments, sometimes you'll have to have a close look to see whether they all apply or whether just some apply. So different to the situation previously under Fair Work, if there is an enterprise agreement in place, it effectively takes over. The modern award no longer applies to you. The two of them don't work together. All right, look, that's my commentary on National Employment Standards and the new modern awards setting a safety standard for us. Next week we'll talk about enterprise agreements, and of course they're in the same sort of vein. That's where the workforce at a particular enterprise gets together and works out a bargain with the employer and creates an enterprise agreement which again has the force of law.